So, good afternoon, ladies and gentlemen, distinguished guests, guest panelists, members, partners of EuroCham Cambodia. Good afternoon, Your Excellency Panon, Delegate of the Royal Government of Cambodia in charge of the Directorate-General of Consumer Protection, Competition and Fraud Repression, Directorate-General CCF of the Ministry of Commerce, and also CCF colleagues. Thank you for joining EuroCham's and DFDL and also the CCF webinar this afternoon on the newly enacted Cambodia competition law. Thank you so much for joining us. So without any further delay, I would like to first welcome everyone to the webinars with a quick welcome remarks from Mr. Denis Saint-Maurice, Executive Director of EuroCham. Thank you, Denis.
Thank you very much, Ratanak. It's my great pleasure actually to welcome all of you, but also, of course, our participants for this online webinar. We're also very pleased that we are organizing this webinar with our national counterpart, the Ministry of Commerce. We have so many initiatives ongoing. Few days ago, it was about organizing side event of the 13 ASEAN Summit organized by Cambodia. And also in the future, on the same note, we are very, very pleased to work with Cambodia to accompany the chairmanship of Cambodia of the ASEAN. So I'm sure that there will be a lot of room for discussion and partnership with the Ministry of Commerce and on the large broader approach with the Royal Government of Cambodia to ensure that the legal ecosystem in Cambodia is more and more attractive and progressive. I have to say that this webinar is one of the many initiatives we show how fruitful cooperation between EuroCham and the Royal Government and our partner DFDL benefits the private sector and stimulate public and private dialogue. We are all aware that the Royal Government of Cambodia, through different mechanisms, ADOT mechanism, GPSF mechanism, is in favor of such dialogue. We are proud actually, but together with DFDL, the Ministry of Commerce, and in particular the protection, the Consumer Protection, Competition and Fraud Repression Directorate-General, CCF, we can host this webinar on the newly enacted law, competition law. Regarding CCCF, I will take this opportunity to thank this particular General Directorate for the very fruitful collaboration that we have this year with 1 year of engagement on another topic, but also something quite progressive, which is the consumer protections. All of these initiatives together make Cambodia more and more attractive as a premium destination, both for trade and investment. We have a track record of delivering high quality seminars and webinars with both, and I'm sure today will not be any different. When I say both, I'm referring to Ministry of Commerce and DFDL. And I'm sure today will not be any different. Looking at the panel of expert speakers and guests that is gathered today for this online webinar. As mentioned, we hope that this webinar will not only be informative, but also that it functions as a forum for all stakeholders to present their views on this exciting new law, and that we can come up with new ideas, and also thanks to questions from the audience that will support the further legislative process and implementations. On the same note, regarding the progressive step taken by the Royal Government of Cambodia, I'm pleased also to announce today that on 23rd of December, we will have another webinar with His Excellency Sokchanda Sopir in order to present the new law on investment. I'm back to this new competition law in Cambodia. It's another step forward towards an even more progressive legal framework that will support Cambodia economic growth in the long run, and also, of course, contribute to foster the economy and the economic rebound after the after the COVID-19 crisis. Competition law is of course not the easiest area of the law. It is rather a technical matter, but one which may heavily affect the behavior of companies. So I'm very, very thankful for the level of expertise that was gathered by the partners and by my colleagues to be able today to share their views, their knowledge, and to respond to the question of the audience. It's important that this new law develops as a tool for creating a level playing field between all business in Cambodia, which is its very essence. It's very important to focus on this matter, to have a level playing field. But that has to be applied to everyone. We must, in this perspective, be vigilant, but it does not further increase the gap between legally compliant and non-compliant companies, but in the opposite, that it will contribute to decrease the footprint of the grey economy in this country and generate more revenues for the Royal Government of Cambodia, and give to all the players a fair, competitive context. In this regard, I refer to our business confidence survey, which we conducted in 2021. Unfair competition took the third place in the main problems in the business environment in Cambodia. At least it is the perception of our member, after non-transparent practice and bureaucratic procedure. Let's hope that this wonderful initiative taken by the Royal Government of Cambodia and this today webinar will contribute to achieve such result, and contribute also to reduce problem that the business community could face in Cambodia. I wish everyone a successful and insightful webinar today. I express my respect to His Excellency Pan Hoon, and I wish to thank all colleagues for their involvement and the preparatory work done. I now wish to give the floor to His Excellency to deliver his opening remarks. Thank you very much.
All right, thank you, Dennis. I'm so delighted to be invited to join the special event for this session this afternoon. With my sincere respect to Dennis Saint Mary, the Executive Directors of EuroCham Cambodia. With my sincere respect to Mandru Tipe, the Chairman of the EuroCham ICT Committee and CEO, and the co-founders of Click, and then Mr. No Checklin, Advocacy Managers, EuroCham Cambodia, Mr. Chris Robinson, the Partner and Deputy Managing Directors, DFDL Cambodia, Mr. David Fruitman, Regional Competition Law Expert, DFDL, Mr. Cheng Novia Ancien, the Partner and Directors, at the City Star Group, independent directors at ABC Bank, and director at Asia Government Cambodia Co. Ltd. Excellency, ladies and gentlemen, a very good afternoon from CCF to you all. At the outset, on behalf of Excellency Pan Surasa, the Minister of Commerce, and also the Chairman of the Consumer Protection Commission, I would like to compliment the EuroCham, DFDL, and the CCF team for organizing this webinars on the newly enacted Cambodian competition law. This is the first webinar and the commemorable initiative toward increasing the awareness about competition law among the business community and other stakeholders. I believe that these will contribute substantially to the spread of the competition culture and improving the level of compliance of the competition law, which in the end would be beneficial both for the economy as well as the individual businesses themselves. Executive Director, Excellency, ladies and gentlemen, just allow me to take this opportunity in briefing you on the historical development of Cambodian competition law, as well as its benefit to consumer and national economic development. Cambodia succeeded in becoming the 148 members of WTO in 2004. With the condition to be the members of WTO, Cambodia is required to implement the commitment with WTO to prepare and reform some legislation to open its market for trade, to enact the competition law, which is one of the Cambodia commitment to WTO membership. In addition, in 2007, Cambodian leader, along with the other ASEAN leaders, declared that the ASEAN Economic Community Blueprint, AEC Blueprint, would transform ASEAN into a single market, production-based, a highly competitive economic region, a region of equitable economic development, and a region fully integrated into the global economy. To achieve this goal, as outlined in the AEC Blueprint, all ASEAN members, including Cambodian, would endeavor to introduce a competition policy and law by 2015. Through this commitment with WTO and the ASEAN for the establishment of ASEAN Economic Blueprint, Cambodia, which has the Ministry of Commerce responsible for drafting this law, have gotten various technical assistance and competition experts for formulating competition law. The technical assistance were from various countries and development partners, starting from 2005, such as United Nations Conference on Trade and Development, UNCTAD, and the ASEAN Development Bank, ADB, and AANZ FTA Competition Law Implementation Program in ASEAN called CLIP, and German Development Corporation, GIZ. As a result, on 5th October 2021, Cambodian competition law was signed and promulgated by His Majesty King Rodam Sihanouk, bringing competition law to all 10 ASEAN member states, AMS. As envisioned under the AEC Blueprint, the enactment of these laws certify one of Cambodian obligation to not only ASEAN, but also to the WTO. Executive Director, Excellency, ladies and gentlemen, why should we focus on competition policy and law, and why do competition policy and law become the Cambodian commitment to WTO and ASEAN? Competition encourages healthy businesses, rivalry, environment, foster a level playing field, as mentioned by Dennis, among rival firms, and improve the mobilization and allocation of resources within and across economies efficiently. The increase of competition not only provide consumer the goods and service with a number of choices, high quality and cheaper price, but also promote productivity, innovation, which are the key elements contributing to the whole national economic growth. Competition policy and law is vital to achieving this outcome, as described above, because competition policy and law could tackle all the issues related to collusion, conducted by businesses and abuse of market power conducted by dominant firms, and it could also prevent any business combination with harm to the competition process in the market and could lead to monopoly. But what does that translate to in practice? Competition policy and law not only can help to create a healthy business environment where small and medium can prosper through the protection from unfair competition conducts of the big firm holding the market power, but also build trust with the foreign investor to invest directly in Cambodia through the establishment of the level playing field with fair competition between domestic and foreign firms, as regulated by the competition law. The increasing amounts of small and medium enterprises, as well as foreign investment, will promote employment rate that can help to alleviate deviation and where ultimately help the economic growth. Executive Director, Excellency, ladies and gentlemen, with the competition law in place, establishing a Cambodian commission, CCC, is our next priority. The CCC will be a sole body responsible for developing and implementing the competition policy and law, as well as other regulation and rules related to competition, where it has CCF as secretary of the secretary. By the same token, the commissioner will compose of a number of representatives from line ministry. Independent experts work together to establish provision, procedure applicable to unlawful practices of restraining of the competition and to promote and protect the benefit of competitive market economy for Cambodia. Currently, CCF have also been undertaking preparatory and fundamental work for setting up the commission, as well as before commencing the enforcement, such as drafting subdegrees on the organizing and the functioning of CCC, subdegrees on condition and procedure for basic combination, which is known as merger acquisition, and draft forecast on selection, procedure of independent commissioners, and other important enforcement tools under this law to come forward. In terms of capacity building, CCF official has also been undertaking capacity building in a various way prior to and after the enactment of the law with the mature competition agencies such as ACCC, the United States Department of Justice, the Indonesia Competition Commission, ICC, and the Philippine Competition Commission, PCC, and so on and so forth. Other than the competition enforcement, CCF is also being a secretary for the National Commission for Consumer Protection, NCCP, under the laws on competition to ensure that the consumer rights are protected and consumer welfare is fully promoted. To this end, the Ministry of Commerce of the Royal Government of Cambodia, with the responsibilities of enforcing competition policy and law, strongly hope that all participants will be able to gain new knowledge from today's speakers and able to discuss the possible contravention and sanction under the Cambodian competition laws. Again, I wish this webinar to be fruitful and to have a better result. I would like to announce the webinar open from now on. Thank you very much for your kind attention.
Thank you so much, Your Excellency Panon, for your insightful opening remarks. So before I move on further to the next agenda item, may I please remind our audience that you may also already drop your question if there's any for the panel discussion later. You can do so through the Q&A function below. Also to mention that today's webinar session is with the support, of course, of EuroCham's annual partners throughout the years, and we thank you so much for their support. So next, may I please invite Mr. Pan Udam, the Deputy Director of Competition Department at the Ministry of Commerce, to give his presentation on the law provisions and its enforcement plan. Thank you.
Yes, thank you, Ratana, for the introduction. and as well as thank you to all the participants who are joining this online webinar today. Before going to the presentation, allow me to take some time for sharing the screen. Yes. So can everyone see the share slide?
Yes, thank you.
Okay, as to start with, as His Excellency Delegate of the Royal Government has mentioned, the Cambodian competition law, if we frankly, is the baby law in the ASEAN region. We consider as the new player in the competition field in ASEAN, as our law has just been enacted on the 5th of October 2021. So basically, we are the new player in this long time playing field. So the presentation today covers 7 topics. The first one will be the general provision of the competition law, and as well as the competition institution, which will be the institution who will govern the competition law, as well as which activity that are considered to be the activity to prevent, restrict, or distort competition, as well as how the complaint and investigation procedure will take place whenever there's a breach of competition. I will also touch up on the penalties deriving in the competition law, and as well as the exemption which the competition law provided to the person who perform the activity that may prevent or restrict, distort competition. And lastly, I will touch up upon the current stages of the law, and also the enforcement plan in the future. For this slide, I would like everyone to just remember this, because I always tell my official that please remember how many chapters that the law have, how many articles that the law have. So this is the basic fundamental thing that the officer needs to remember, and for easy understanding, I always tell them that please remember that there are 7 days in a week. So remember, 7 days is 7 chapters. And in Cambodia, we used to have a slang through social media, which is sai mui, it means that 41. So basically, everyone remember that 7 days, 41 articles. So this is what I told my official to remember. Yeah. So the competition law basically governs the activity that prevent, restrict, or distort competition. But the main purpose of the competition law here in Cambodia is to promote fair and honest business. Also, this with the fair and honest business, it can increase economic efficiency and encourage new business to enter into the market and compete with other businesses. But the most important thing that the competition law governs is to provide the consumer with a good or high quality products or services with a fair or low price. Most importantly, is diverse and versatile. Basically, that we give the consumer choice. So the consumer protection law not only protects the companies or the competitor in the market, but also it provides consumer with good quality products, affordable price, as well as the choice in order to choose the products and services that they are willing to buy. We look upon the scope of the law. So the scope of law, it doesn't mean that whether the activities took place in Cambodia or outside of Cambodia, but if those activities significantly prevent, restrict, or distort competition in the market of the Kingdom of Cambodia, then this law applies. the scope of the law applies to that activity. For example, if the activity took place in Thailand, but the effect of this activity, it has the effect in Cambodian market, so it will be governed by this law. We touch upon the establishment of the Cambodian Competition Commission. May I take this opportunity to update everyone that right now with the lead from His Excellency Delegate of the Royal Government, the team who drafted the sub-decree on the establishment of the Cambodian Competition Commission is at the second stage. So we will defend the draft sub-decree with the team, interministerial team at the Council of Ministers on the 8th of December. So the functioning and organization of the Competition Commission, Cambodian Competition Commission, or the CCC is it will be led by the Minister of Commerce. So the Minister of Commerce will be the chair of the newly established CCC with representative from relevant ministry. But I would like to inform everyone that the CCC is a bit of a unique commission other than other commission which has been established in Cambodia. The CCC will consist of what we call an independent commissioner. So who is the independent commissioner? The independent commissioner comprised of one former judge, two individuals with legal or knowledge experience, and two individuals with economics knowledge and experience. The reason that we have an independent commissioner is to push forward the work related to the decision making in terms of competition problem, because we look into other commission whenever we need the commissioner to come and meet each other, it's quite of a big work. But if we take this case and apply with the CCC, we have an independent commissioner, and then they will sit with each other, and then they can act on the problem fast, rather than we have to invite all of the commissioner from various ministry to come and decide on the case. One important body of the CCC is the Directorate-General of Consumer Protection, Competition and Fraud Repression, or Directorate-General, or we can say that CCF. So in this case, in order to enforce the competition law, which means that we have to make the investigation, the CCF will be the directorate of the CCC, and CCF will be the enforcing body of the competition law as well as the consumer protection law. So what is the function of the CCC? The CCC will issue decision, will issue orders, will issue interim measure when it feels that interim measure is needed in order to postpone the effect which may prevent, restrict, or distort competition in the market. Also, the CCC would issue an administrative sanction to give notice to companies or person who may violate the competition law. Lastly, the CCC will impose fine in order to impose fine to the person which violates the competition law. So this function has been stated in Article 6 of the newly enacted law on competition. In the law on competition, we have categorized 4 activities which we consider that may prevent, restrict, or distort competition. So the activities include a horizontal agreement, vertical agreement, also abuse of dominant market position, and lastly, business combination. So these are the 4 activities which may prevent, restrict, or distort competition in the market. I would like to brief about what is a horizontal agreement. So basically, if you think of this way, if a shop is selling a beverage and another shop is also selling beverage, and it's in the same level of each other, this is called a horizontal agreement, and they agreed with each other in order to maintain price, to control the market on goods or services. So this is one of the example of the horizontal agreement. So if you can see in the slide, you see A is agreeing with B and agreeing with C. So they are making a horizontal agreement. Article 7 of the law on competition also stated about which activity or agreement that are considered to be a horizontal agreement. So if an agreement is directly or indirectly affect the competition, and it has the effect of fixing, controlling, or maintaining price of goods or services, then it's considered to be an horizontal agreement. Also, some agreement can which could restrict competition by limiting the limitation of quantity of goods or service, or the types of goods or service which are made available for sale. Also, the limitation of the development of new goods also considered as an horizontal agreement in this case. Another common activities that we see in the market today is the allocating of geographical area between competitors. So in this agreement, if it's restrict or distort competition or preventing any competition, it will be considered as horizontal agreement. Not only the geographical areas, but if the agreements allocate customer between competitors, then also this is considered horizontal agreement under the new competition law. The last point is favoring one bidder in bid for a contract in private procurement. So in this case, the competition law only covers private procurement, but state procurement, then this is governed by another law. But the competition law only looks at contract in private procurement. Next, we look at vertical agreement. So I always think that too easy to understand is, for me, a vertical agreement is from top to bottom. Basically, it's from the producer to the wholesaler to the reseller. So it's an agreement which may prevent, distort, or restrict competition from producer, from wholesaler or retailer. So basically, the person from top to bottom agreed with each other, and this agreement may have an effect on competition in the market. So what are the activities that consider a vertical agreements in the market? So if you require a purchaser to resell purchased good or service only within a defined geographic area. Also, number 2 is requiring a purchaser to resell purchased good or service only to specific customer, specific category, or specific category of customers. So in this case, if you required a reseller to resell the goods in a particular area, or resell the good to a specific customer or a category of customer, then this activity may be considered as violation of the competition law. I use the term may is because that the determination of the violation of the vertical agreement in this case will be used by the term rule of reason. So if the activity is being conducted, but the person who conduct the activity can prove that this activity does not violate or distort competition, then they may not be governed by the competition law. So in this case, a rule of reason concept is being used to determine whether there are any violation of competition law in the vertical agreement. Also, the activity which requires purchaser to purchase all or nearly all of the requirements in a particular good or service, preventing a seller to sell goods or service to another purchaser, requiring a purchaser to purchase unrelated good or service in addition to the goods and services that the purchaser wants. So in this, the 3 point is, this is easy to understand, is you force someone to do something. In this case, if you force someone to purchase something that is not related to the good or service, this may violate the vertical agreement under the competition law as well. We go to another pillar of the competition law, which may be considered as the activity that violates the competition law, and then this is abuse of dominant position. The abuse of dominant position is where one person who had market share, who had market power, creates a barrier to entry or uses sunk costs to eliminate other competitor in the market, because they are the one who holds the market. They are the one who can shake the market, if I may say. In this case, they use their activity, they use their dominance to eliminate other competitor from the market. So if you can see in the picture, the person with the big body and with 80% of the market, it means that he or she can control 80% of the market. So in a Khmer term, you can say that when a giant shake, the ants tremble. So basically, if this person use their dominance position in the markets, which he control 80% of the market, he can eliminate the competitor from the market. The activities which consider that the person use dominant position in the markets are: one, required or inducing a supplier or customer not to deal with a competitor, refusing to supply goods or services to a competitor, selling goods or service on the condition that the purchaser need to purchase other goods or services separately, which are unrelated to the object and contract, selling goods or service below the cost of production, or refusing to give a competitor access to essential facility. So of all the activities, in my opinion, I think that number 4 is the most dangerous one. So if you hold a market power, you hold your dominance position in the market, and you want to eliminate your competitor, activity number 1, which you sell the goods or service below the cost of production, can eliminate the competitor from the market fast. For example, if you have a lot of money, a company have a lot of money, and then they want to eliminate a small company which compete with them, they just sell their product in a low cost, and then the small company cannot cope with the effect of this selling. They cannot compete with the big company. So in this case, the small company will eventually go out of the market, and the person who controls the market can increase the price at its will. And the last pillar of the activity considered to violate the competition law is business combination. So any business combination which has or may have the effect of significantly preventing, restricting, or distorting competition in the market shall be prohibited. So in this case, the competition law does not tell that company cannot combine with each other, or company cannot work with each other. But in this case, when company decides to buy another company, or to joint venture with another company, if this activity does not have any effect on competition in the market, then it is okay. But if the business combination have effect which result in the prevention, restriction, or distortion of competition in the market, that activity of business combination is prohibited. But in this case, business combination is the subject to examination, inspection, and evaluation of the effects on competition. And the body who will conduct the examination, inspection, and evaluation of competition by business combination will be the CCC. I received question where people ask, how do we complain in competition cases? In this case, the CCC has the authority to receive complaint, not only from the competent regulator, not only from person who has been violated by some activity from others competitors, but the CCC has the power to initiate its own complaint whenever it feels that competition in one sector is being violated, or are there any effects on competition amongst competitors in a particular market. So the three complaint mechanism has been shown on the slide. So one, the CCC can initiate in its own complaint, and also we can receive complaint from a competent regulator, as well as the person who's been violated by activities of their competitors. Another unique thing of the competition law is the competition law of Cambodia provides the rights of the CCF Directorate-General officer to be the investigating officer. So which means that the officer of the CCF Directorate-General will given or nominated to be an investigation officer, as well as in this a judicial police. It means that they have power to investigate, search, or collect evidence, or ask individual for questioning, to gain information, document, or any other evidence that can help to crack the competition cases. So, but not like consumer protection law, not every CCF Directorate-General officer will grant this special rights. In this case, a competition case is a bit complicated, so we have to make sure that the person who's being nominated is competent to take on this heavy burden. I would like to go to the penalties under the competition law. So the penalties under the competition law shall be written warning. So this is the first stage when if you found out, sometimes you found out that you violate the law. You'll receive sanction, also include pecuniary fine, as well as financial penalties and imprisonment. And the most important that I think that it will scare violators is the suspension or revocation of the business registration certificate or business license or permits, because this will put consideration to violators. As you may know, in order to build a company which have customer loyalty, it will take a long time. So if we impose on the point number 4 of the suspension and revocation of the business registration certificate, put a scare into the violators. As I mentioned earlier, there are 4 pillars of activities which considered to be a violation of the competition law. But for penalties related, so Article 9 talks about vertical agreement. Article 8 talks about vertical agreement. Article 9, abuse of dominant position, as well as Article 11 talks about business combination. So in this 3 article, the penalties of the violation includes a written warning and a fine of 3% up to 10% of the person's turnover. It means that we cannot impose an actual fine in this case, because the company may whenever the company violates under these article, they can generate a lot of income. So if we we impose an actual number, sometimes the benefit that we receive is far more greater than the fine. So they just pay the fine and they'll be okay. But in this case, the fine will be 3% up to 10% of the turnover, and the violation fines will not exceed 3 years of the activities that the person conducted. And in this case, if they have received a written warning and a fine before, and they continue to do this activity, then the last step will be to revoke their business registration or certificate of permit. In Article 7, which talk about the horizontal agreements, so the fines under the horizontal activity which violate the Article 7, we have separate into the 2 sections. So one is for natural person. If a person and individuals participating in horizontal agreements, so if found guilty, they will receive an imprisonment of 1 month to 2 years, and a fine of 5 million reals to 100 million reals. But if this entity is a legal person, so for example, company or companies participating in a horizontal agreement, they will face, if found guilty, they will be fined from 100 million to 2 billion reals. So this is quite a big fines. Of all the activities that being mentioned before, even though the law stated that some activities are considered to violate the law, but an exemption scheme is being implemented. So if an activity is being conducted, but those activities can prove that there are significant identifiable technology, economic, social benefits, then these activities are exempted from the law. So you can conduct those activities. Even the law stated this activity may prevent, restore, or restrict competition, but if the activities can show that it will have a benefit on technology, economics, or social, then this activity may be granted an exemption. Also, such benefit would not exist without those agreements. It means that if there's no agreement, agreement under Article 7 or Article 8, then there's no benefit on technology, economic, or social. So in this case, this agreement is needed in order to gain the 3 benefits mentioned above. Also, those benefits significantly outweigh the effect caused by any determined preventing, restricting, and distorting of competition. So in this case, if the benefits is far more greater than the negative impact on the market, the activities may be granted an exemption under the Article 12 of the competition law. And the number 4 is easy to understand. So if the activity does not eliminate competition in the market, then they will receive maybe receive exemption under the law. So any person considering that an agreement or activity may violate Article 7, 8, 9, or 11, they may apply for an exemption to the CCC. And this case, the CCC shall grant the exemption if the agreement or activity does not violates this Article 7, 8, or 9. So in this case, if the CCC found that the competition in the market does not is not affected by this activity, then they will grant exemption on the person who applies for exemption from the Triple C. So if in this case the CCC feels that a certain categories of agreement or activity in relation to a particular goods or services fulfill the requirements, which mean that the 4 requirements from Article 12 of the law, the CCC may grant a collective exemption to a group of people. So not only an individual can receive exemption, but a group of collective exemption may also be given if the activity does not if the activity fulfills the requirement of Article 12 of the law. Yeah. On the last slide, this is a way forward of the CCF Directorate-General. So right now, after the law is enacted from the guidance of His Excellency Delegate of the Royal Government, we have CCF officials have been undertaking capacity building. In this case, we have conducted 7 training for CCF official already. Keep in mind that the CCF official, we have 600 officials, and the official in all of 25 provinces across the nation. So we have right now we have conducted seven training already to give them ideas, to give them information on the newly enacted law, and to give them a general perspective of what the law, what is the law, what activities consider to be violation under the law, and also what are their rights as an investigating officer, as well as judicial police. So right now we have trained 350 officials already, and the training will go on. As well as in this case, we also with cooperation with the GIZ and under the COMPETE project, CCF has completed several enforcement tools under the Cambodian competition law. So it is to be adapted once the Cambodian Competition Commission is established. So after training our official internally, CCF will conducted a nationwide advocacy program in 2022 to raise the awareness of the benefit of the competition policy and law, as well as the Cambodian competition law. So in this case, not only we provide we do the advocacy internally, but we want to spread and share the importance of a competition law to the public, to other stakeholders such as businesses, as well as consumer association as well. So this is all for my presentation today, and thank you so much. And I would like to give the floor to our lovely MC.
Thank you, Dom, for your insightful presentation, and it is very detailed, and really appreciate for your presentation. So allow me to introduce our next guest panelist. So we're having, I'm sorry, 1 second. Yeah. So yes, we will be having Mr. David Fruitman, the competition expert at DFDL, for his time to give here the presentation on the underlying competition issues that businesses should consider. Okay, so David, I now pass you on the floor. Thank you.
Oh, great. Can you move the slide forward, please? Thank you. So good afternoon, everyone. Thank you, His Excellency and Udon, for your informative remarks. I'm going to warn everyone right now that I'm having power issues, so I may switch to my colleague's computer, but hopefully we should be able to get through this. Thank you again to the organizers, panelists, and the participants for taking the time in this new and pervasive area of law in Cambodia. I try not to duplicate too much of the comments before that, but get through some of the basics of issues that we expect to arise here. I should note that, as has been mentioned, this is a new area of law. There's a lot to be expanded on in decrees and enforcement tools that are being worked on right now. So these, where there's opinions offered, they're my opinions, and they should not be taken as gospel or set law, because the law is not fully developed yet. So basically, what I'd like to do is review a few things about why businesses should care about the law, and then some of the issues that have been addressed in part, and expand on a few issues that are a bit more targeted. Next slide, please. So again, this is a pervasive area of law. It will have implications across the entire economy and most business practices. His Excellency and Udon have already talked about the scope of the law, and you've heard comments about level playing field. Basically, the competition law is one of the key laws that sets the rules for a market-based economy, which leads to the benefits of consumer welfare and the benefits of a competition in a marketplace. So this goes to what was spoken about earlier as to cheaper goods, more innovation, quality of goods, etc. If we differentiate between consumer protection law, which focuses more directly on the impact to consumers, competition law focuses on the ability of the market to generate this innovation, this better pricing, this higher quality. The law, as we mentioned, hopefully will create a level playing field that will not only protect Cambodian businesses domestically and enhance the ability of small and medium enterprises to compete, but will also make Cambodia a more attractive market for foreign investment, with certainty that foreign entities competing here and investing here will be treated into that level playing field of equal opportunity to compete. And again, I stress, competition law is not about equal competition. Competition is a dynamic process, but it is about an equal opportunity to compete without the fear of anti-competitive conduct. Next slide, please. So the scope has already been talked about a bit, but I want to reiterate, the scope of the law is not restricted to actions or agreements that take place in the Kingdom of Cambodia. It's focused on market impacts inside of Cambodia. Whether an agreement takes place outside of Cambodia or partially outside of Cambodia, whether it's a merger, whether it's vertical conduct that has been talked about, if it impacts into Cambodia, it may be covered under the competition law. So the fact that it's a market-driven test and not a geographic restriction of the origin of the conduct or agreement means that anybody who's doing business in Cambodia, potentially even through subsidiaries or export into or import into Cambodia, has to consider the ramifications of this new law on their business practices. Next slide, please. The other area that hasn't been drawn out yet, and I think this will take some time before it fully develops in Cambodia, is there's an abrogation clause in the competition law. So that all of their laws that are contrary to the law of competition are abrogated or rendered essentially moot, void, where they contradict the law of competition. This can impact greatly on sectoral regulation. There are other laws in Cambodia that deal with competition or competition-related issues, and again, the competition law itself is meant to dominate. That being said, as Udon mentioned, the Cambodia Competition Commission is expected to be largely composed of ministerial representatives. So it's not that the CCF or the CCC will dominate competition. They'll be working with the traditional regulators and ministries that have power, and those regulators may even be part of the CCC. But it's important to stress that the primary source of regulation of anti-competitive conduct will be the competition law. And therefore, it's important for businesses, regardless of what sector they're in, to focus on how this law may impact their conduct. Next slide, please. So one of the things that's an important concept is this idea of per se versus rule of reason. And it's important because it will help businesses evaluate the nature of their conduct, their existing conduct, and their ongoing conduct in light of the various prohibitions under the law on competition. And this is a gross oversimplification for which my law professors would probably fail me, but a per se offense exists where the conduct itself is the offense. It's an actus reus. There's no element of the object or effect. Just, for instance, entering into an agreement itself is the offense, regardless of whether it is effective or what the object is. That type of investigation is actually fairly straightforward and echoes many other areas of investigation and across many other regulatory regimes because it's purely factual. Did people engage in this conduct? What is somewhat unique to competition law is the rule of reason, which imbues the analysis and the investigation with an economic analysis, where you tend to look sometimes at the object, which is much more straightforward, but often the effect of conduct, in order to determine whether that effect significantly prevents, restricts, or distorts competition in a market. That is an extraordinarily complicated investigation and takes not just sort of traditional means of factual investigation, but economic and legal analysis in order to determine whether the conduct has the effect and what is the requisite standard of effect. What makes it quite difficult is conduct that might be problematic in one market or sector may not be problematic in a different market, or it may not be problematic at a different time or conducted by a different entity. Further, it makes use of precedent quite difficult because conduct that may be problematic in one jurisdiction may not be problematic in our jurisdiction. So again, it makes a lot of the analysis very fact-specific and very difficult. And this is why when Udon is talking about all the capacity training, this is an important area for the CCF because this is an area, this economic law is a fairly unique animal in law. Next slide, please. So it was mentioned about agreements and horizontal and vertical agreements. I just want to focus on the breadth of the definition of what is an agreement, because often, especially when you hear a lawyer talk, you think of agreements as formal written contracts. That is not an agreement in competition law, and the definition used in the Cambodian competition law is aligned with what we would call international standards of what is an agreement in competition. And I'm not going to read the whole thing. It's not only in the law but in the materials. But again, you have to focus on it's almost any type of agreement. It can include communications, and it also includes what we often call as a coordinated conduct or concerted practices, where there is actually no agreement between the parties. The parties have never said, we will do this together. But it often is involved with things like information exchanges, where a company will give information publicly or distribute it to its competitors with the idea that they will align themselves with that conduct. For instance, somebody might announce a price increase with the understanding that its competitors may also do it without a formal agreement. The determination of whether a concerted practice actually happens is quite difficult, but Cambodia has wisely chosen to accept that there are areas of business practice where there may not be a formal agreement, but which may have a detrimental effect on competition. And this is something that businesses have to be concerned about. Next slide, please. So in general, when you think that an agreement is much broader than what you might think of as a written contract, you then have a whole bunch of situations where your conduct that you might currently consider non-problematic may in fact come within the auspices of an agreement under the competition law. They can include things like informal discussions. It's very common that, for instance, sales representatives from different competitors may meet together, especially if they work in the same regions. But the discussions they have may create agreements. Easy example, one sales representative just simply states, I'll focus on the clients in this side of the province, and you focus on the clients in that side of the province. That may not be anywhere above the sales representative level, but it would still constitute an agreement that may be problematic under the competition law. Another area that is very commonly looked at is business associations. And I do take the irony that a business association is co-presenting this. But business associations actually have been quite problematic in terms of competition agreements. And Vietnam, our neighbor, has had a number of examples where business associations essentially led horizontal cartels. They did this because prior to the competition law, this conduct was considered normal. And there is other examples, Singapore, Indonesia, etc., where similar conduct was done through business associations, either by the members themselves or sometimes because it was not illegal before the law on competition or the local version of that was enacted, it was done quite explicitly. In one case, in Vietnam, an association actually published the agreed price increase of all its members because that was normal conduct before the law on competition there. The last is information sharing. And there have been a couple of cases recently in ASEAN as well as in Australia, in the hospitality sector in particular, where passing on of hotel rates, for instance, was considered a coordinated part of a coordinated practice. Even though hotel rates themselves may be public, for instance, on booking.com or Agoda or on the hotel's website, there is some information that was considered confidential or proprietary that was shared among the competitors. And it was a determination that this was done in the nature of a concerted practice. So even information sharing may be problematic. Again, there's a lot of considerations that have to come in. This is a new area of law here. Next slide, please. So horizontal conduct in Cambodia is treated on a per se basis. And these have already been reviewed, but these are the traditional sort of internationally accepted hardcore cartels. And they're often treated on a per se basis in a number of jurisdictions, and in fact are treated criminally in many jurisdictions. And these, again, where you have an agreement between competitors or potential competitors, a horizontal agreement, the entry into the agreement itself is prohibited, regardless of its effect or object. And you can see in COVID period, there's been a number of exemptions and guidelines issued by regulatory authorities around the world as to when competitors can enter into these kind of agreements in order to deal with the pandemic. But in general principle, agreements between competitors that address these issues are extremely problematic. Next slide, please. Vertical conduct is a little more complicated. Now, the easy one under the law is minimum resale price maintenance, because again, that is per se. Entering into an agreement that restricts the ability of your purchaser to resell at below a minimum price is per se prohibited under the competition law. And in fact, the offense is a little broader than that, where it's direct or indirect or similar conditions. When you get to vertical agreements, which were reviewed and abuse of dominant position, again, you have that rule of reason analysis. So a very careful examination of the conduct, the market players, and the effects or objects have to be done not only from a legal, but from an economic perspective. Next slide, please. And yeah, I am trying to go relatively quickly because I was told at the beginning of this that the panel is the key part of this workshop. So I think we want to get to the panel and is avoid. You don't have to consider whether there's a dominance issue. These apply to all businesses, regardless of market power, and they look again to the object or effect of the conduct. Earlier Udon mentioned exemptions, and this is an area where there is very common for parties in other jurisdictions where they have agreements that may address these things to either consult informally or formally with the regulator, or potentially seek a individual or block exemption. because again, there's enough analysis required that it is not always clear whether there's a potential offense or not. Next slide, please. Abuse of dominance is a little bit more difficult. Abuse of dominance, and I've tried to really simplify the analysis, and this isn't done so that you come running to lawyers. It's done because, again, these are the steps you basically have to review, and these are probably the steps that the regulator, the CCF, will be reviewing and then presenting towards the CCC in terms of making a decision in these areas. You first have to find an entity with a dominant market position. And the law defines it as being able to act significantly without constraint from competitors. And Udon's slide showed an 80% versus 20% of the market. And I should note that market share, while it's a necessary element, is not sufficient to determine dominant position. It is one significant part of the analysis. But to use the example that was given, you could have a player that is 100% of the market, but pretend, let's say, a power generator. But if their purchaser was the government power distributor, they may not, the power plant may not have any market power. You could have a monopoly or an 80% where there are low barriers to entry. In other words, if someone tried to exercise market power, more competition would enter. So again, barriers to entry was on the list of elements Udon presented, and he went through the materials quickly, and I just want to make sure it's clear. Determining dominant market position, we do not know yet how that will be determined in Cambodia. There's no market share test, there's no guidelines yet, but determining whether market power exists is not just a question of market share. There's a market analysis that has to be done. If an entity does have a dominant market position or market power, and again, I want to focus on the definition really quickly. The reason why this is important is because if competition law is the rules of a market economy, market generates consumer welfare and benefits by the act of competition. By knowing that you have to actively compete prevents you from overly pricing, prevents you from not innovating, prevents you from restricting quality of goods. So if you could act without fear of your competitors' actions, that allows you to do things that may not benefit consumer welfare and may be anti-competitive. So if one has a dominant market position, the next question is your conduct relate to any of the listed activities? And again, those have been reviewed already. Step 3 is now questioning the object or effect, because this is not a per se offense. Even if you have dominant market position, even if you engage in this conduct, it still may not be prohibited under the law. So you then turn to determine either the object or effect of the conduct itself. Sometimes companies can determine this themselves. Other times they may seek expertise. Sometimes, again, they may seek guidance, either formally or informally, from the regulator as to the nature of the conduct. But however it works, the key is always going to be that you have to have all these steps. And the last step is whether there's an exemption. And there are actually 2 types of exemptions that may apply with respect to an potential abuse of dominance. General exemption that was provided, but there's actually a special exemption under the abuse of dominance provisions that provides that somebody can legally perform activities that may otherwise be prohibited if 2 conditions are fulfilled. One, there's a reasonable reason to legally perform the activities for the benefits of the business. In other words, there's a logical and reasonable business purpose. It's not an anti-competitive, it's purely an anti-competitive object. In other jurisdictions, there's been some contradiction between the object is allowed or not. In other words, it is possible that as long as the pro-business, even some anti-competitive objective or potential objective is allowed, and it's sort of an ancillary effect. But we don't know how that's going to be interpreted here. The next part of the test is that the activities themselves do not significantly prohibition on market. It's not clear, again, how this will be applied. We don't know the standard of this yet. But for abuse of dominance, step 4 actually has 2 different types of exemptions that are potentially applicable. Next, please. So His Excellency mentioned competition policy and law. This is extremely important, and it's also under the auspices of the CCC to look at competition policy. Competition policy is broader and encompasses all other laws, regulations, policies, etc., that may affect competition. And the CCC has actually been granted explicit authority to opine on these, request changes in these, etc. This can include trade law, privacy law, health law, telecommunications law. In some countries, when entities like businesses like Uber and Grab entered the markets, there had to be recommendations on how the regulations would change to promote competition, and that was an area, for instance, the KPPU got involved with in Indonesia. But that being said, while the competition law dominates on specific anti-competitive actions and agreements, there's a lot more to consumer welfare that may fall within either competition policy or other trade practices that are relevant. And so again, relying on competition law alone to consider your conduct is not sufficient. Unfair trade practices are dealt with in part under the consumer protection law. There's privacy law, data protection, sectoral regulations, etc. There's a whole bunch of elements that come into competition policy and a broader perspective of consumer welfare that all have to be looked at. Next slide, please. Sorry, just checking my power. Doing okay. So some key takeaways. First, the underlying issue here is this is a new area of law. It's new for businesses. It's new for other stakeholders like consumers. It's new for associations. It's new for the government. We don't have the CCC, the regulator, the full regulator of the CCC. It does not even exist yet. So if you remember, Udam's last slide talked about advocacy, capacity building and advocacy. Advocacy, I would expect, is going to be a key part of the CCF and the CCC's missions for the next little while. And we can see in our ASEAN neighbors, and this is one of the benefits of coming last and having our law last, is we can learn from what all our ASEAN neighbors did. Because some of the other people who are working with the CCC and the CCF now, the Government Ministry of Commerce and the CCF now, they're from countries that have had competition law for a long time. And they may have forgotten some of these steps. But our ASEAN neighbors, many of them have just implemented their competition laws. And some cases haven't fully implemented. So Cambodia has the luxury and the benefit of seeing how they've done their advocacy, seeing how they've gone through the steps, and we can learn from that. But there is a lot to do because up until now, businesses haven't been concerned about some of these issues. I should say that this is an area where some foreign businesses here actually have a leg up because in some foreign companies, there are global compliance policies and their conduct is already regulated, has been regulated not by Cambodian law, but by the practices and guidelines of the corporate entity as a whole, or the group. Cambodian businesses will have to start thinking about some of the issues that they haven't had to worry about yet and review their conduct, practices, and agreements in light of the new law. In many cases, because the law is not yet clear, it will not be clear what needs to be changed. And I expect that the CCF will be there to help us interpret a lot of these things because we will need their help because the implementing rules, decrees, and guidelines are not yet existent. The second thing is compliance, planning, and policies. This is an essential area, and again, this is something that many multinational companies investing here are already familiar with. But setting up a regime where compliance planning is an important part of the business is essential to prevent things like informal anti-competitive agreements. This is particularly problematic when they're horizontal informal anti-competitive agreements because, again, those are per se prohibited. Communication policies. This is something that businesses will have to start considering because not only is it important to be careful about what information is shared externally, but even what information is provided internally. How people talk about things may one day prove to be evidence of an object or an effect. It may prove to be evidence of whether an entity considers itself dominant. And again, that can be external communications or internal communications. So this is something that Cambodian businesses will have to start paying attention to in a way that they probably haven't yet. And finally, as Cambodian businesses begin to consider their own policies and practices, remembering the level playing field about equal opportunity of competition. This Cambodian law, the new law of competition, gives Cambodian market participants an opportunity to look at the conduct that's happening outside of our country. And we can now look at whether there's anti-competitive conduct happening in other jurisdictions that is hurting our markets or potentially hurting our markets, whether it be a global merger, whether it be a distribution agreement that's imposed from another country, pricing practices, or agreements between foreign entities. In all cases, now, not only can Cambodian businesses consider their own conduct, but Cambodian businesses can now look outside and look at the conduct of international competitors and potential competitors and other stakeholders and consider whether that conduct may infringe the competition law. So this is a very powerful tool to level the playing field between domestic businesses and international competitors and investors. And that is all. I think I've passed this along. Again, thank you very much. I hope that wasn't too quick, but a lot of the information was already provided about the law itself.
Thank you. Thank you so much, David, for your presentation. Just in time for our panel discussions. So allow me to introduce our next agenda for and also what we've all been waiting for on a panel discussion. So may I please first invite and also introduce my colleagues, Mr. Noe Shalik, the advocacy managers here at EuroCham Cambodia. He will be today our moderators for the panel discussions. And I'm also delighted to welcome once again His Excellency Mr. Pan On, Delegate of the Euro Government in Cambodia in charge of the Director-General of the CCF at the Ministry of Commerce. And also welcome our new panelist, Mr. Matthew Tippett. So Matthew currently is the chairman of EuroCham ICT Committee, and is also the CEO and founder of Click Payment. Next, we have on the panels is Mr. Etienne Cheveners. He's the partners and director Asia at City Star Groups. He's also the independent directors at ABA Bank and also the directors at Asia Gourmet Cambodia. Thank you, Etienne, for joining us. Also welcomes again David, who just recently gave the presentation once again to join the panels. So to keep it short, I now pass over the floor to my colleague Noe to moderate the panel discussion. Thank you, Noe.
Thank you, Ratanak, and thank you to all speakers for very insightful presentations. We also got quite a lot of interesting questions from the audience, so I'm going to slightly reverse the questions that I prepared for you. Some of them were also answered during your presentations. So maybe let me start with the first question immediately to David. You spoke a bit about what we can learn from other ASEAN member states, and my first question would really be, can you elaborate a bit on how that new Cambodian competition law, how does that compare to the competition laws in the other ASEAN countries? And can you be a bit more specific about what we then exactly can learn from them?
Sure. I don't want to do a direct comparison. One of the things is, well, there are international, let's call it in quotations, best practices. Competition law is important to be tailored to a market and a jurisdiction. So there's no one right way to write a competition law. But when you look at general principles, His Excellency talked about what is covered here: business combinations, abuse of dominance, anti-competitive agreements. Those are the general three pillars of competition law that most jurisdictions deal with. One of the exceptions to this in ASEAN is being Malaysia, which doesn't have a merger control regime, but even that's changing as they want to impose one, introduce one. But I think what we can learn here is not so much how other countries do the law, or even how they necessarily interpret it or implement it, but what we can learn here is the stages of enforcing sort of investigation practices, best practices in actual the sort of regulatory implementation, best advocacy tools, the best way to promote competition policy, and we can see that. And that, I think, is going to be common in many jurisdictions, or at least lessons can be learned and extracted to the Cambodian specific jurisdiction. The actual interpretation of specific provisions, I think guidance, and I think our representatives of the CCF are best to discuss this, but I think they can be guided or take some notice of what's happening in other jurisdictions. But at all times, it's going to be what isn't practical or proper under Cambodian law. And so the fact that Thailand, Vietnam, or even the United States interprets a provision a certain way doesn't mean that's how it's going to be interpreted here.
All right. So for the time being, then, David, what would be your advice? As you mentioned during your presentation, also the other speakers briefly referred to it. A lot of details, so to speak, or matters of really practical importance. They are currently still unknown. So what would you advise our businesses for the time being? If we cannot look at other ASEAN member states for really the practical points, what should we do?
Well, I think to some extent, you can have a general view, and this is why I differentiate between per se and rule of reason. We already know that the scope of the law is extremely broad. We know that the scope of an agreement is extremely broad. We already know there are some per se offenses. And again, there will be specific implementation that is not set out exactly in the law. Because in any law, one of the problems, of course, is being unilingual. I'm only reading the English language version, and it may be interpreted slightly different in the proper Khmer language. But we can learn, businesses can already start to look at the per se prohibitions and examine their conduct that way. Businesses can also, while they may not be able to determine right now whether they're dominant, they may have some ideas. In other words, if you think you're a dominant, maybe you are. If you can obviously point to things that suggest you have no dominant market position, you're at least in a bit of a safe harbor. But starting to look at those issues and looking around your marketplace and trying to decide, are you potentially dominant or not, is a good exercise to start with now. But at this time, prior to full enforcement and full implementation, I would be a little questionable in what changes are enacted outside of the per se offenses. But again, I think as the CCF engages in more advocacy efforts and engages in more informal consultations, and we can see some of this with the consumer protection law and how the CCF acted with respect to the consumer protection law even before there was a commission in place, that we can expect that dialogues will be welcome, and we can expect, again, I think a cautious approach is normal. And if you look around to other jurisdictions, advocacy was a huge part of the mission in almost every regulator's position when it was introduced. And I think that's fair because businesses are not used to competition law in Cambodia, and they have a lot to learn.
I'm going to quickly insert the question from the audience also to you, David, because it extends on what you have been explaining, but it's maybe a bit the other side of the same coin. Do you have any idea or maybe legal here, but maybe illegal in another jurisdiction?
Sure. Right off, and again, this is just from the language of the law itself. The language of the law, I'm going to stick to per se offenses because, again, we don't have to do a lot of interpretation there. The language of the law prohibits only basically 4 types, and it depends how you list them, but Udon has listed them in more detail than I did. Only those types of horizontal agreements are considered prohibited under Cambodia's competition law. In a number of other regimes, there are other agreements that are even per se prohibited, or at least rule of reason prohibited as horizontal agreements. So right away, and again, this is the letter of the law, there is conduct that may be prohibited in our ASEAN neighbors or in other jurisdictions that are horizontal agreements where there's only an object or effect of an anti-competitive nature, but are not one of the listed categories under Cambodia's competition law. And therefore they are acceptable currently.
All right, thanks, David. Your Excellency, if you allow me a question for you, do you have any further guidance on this matter? Will the Cambodian Regulatory Authority, will it independently develop its own competition policy, or will it be heavily borrowing from other authorities from our neighboring countries, for example?
The sound is not so perfectly heard to me.
Right, I will quickly repeat the question. The question was, Your Excellency, if you have any further guidance on this matter in terms of the development of the Cambodian competition policy. Can you give any ideas whether we will be looking at how our neighbors are doing it, or will we really be independently developing our own competition policy here in Cambodia?
I think what we have taken into consideration with just the best practice from the international, the ASEAN guideline that also give us some of the background, the fundamental input as well on drafting the competition policy in the future. For the law that we draft, we also look into the ASEAN guideline and also from other country pieces of legislation as well. Where we are on board, with the ASEAN, so we have to have a similar type of competition policy and also the laws on competition.
Thank you for that answer, Your Excellency. Maybe let me go quickly to our private sector representatives here. In the presentations we talked about horizontal agreements, and Etienne, a question to you. In your personal experience, your very long experience here in Cambodia, but also in other parts of Southeast Asia, how prevalent really are the true hardcore cartels we spoke about in Cambodia in particular? Is this something, according to you, that is fairly openly done, like the outright agreeing of prices with your competitors, or dividing or developing a joint strategy how to divide the market? Is that something that you see that is very common? And also, what is your feel? Are businesses aware that this is in fact illegal behavior? Or yeah, can you elaborate a bit on your personal experience?
Okay, thank you for allowing me to a few comments. In Cambodia, I've been mainly in the banking sector and the construction sector. So I don't think that in the construction sector, for people who are builders or property developers, there are issues of that kind. There may be issues for when you are purchasing your raw materials, because for certain categories of raw materials, traditionally in a lot of countries, there are suspicions from time to time that competitors are talking to each other, which may be inconvenient. The problem is that it's very difficult to prove, and in all countries it is. So generally, it would be after inquiries by the public sector, means the government itself, that they would patiently unveil some cartels. My only advice today, because we don't have a lot of time, is that since now Cambodia starts to have the same level of law than in neighbor countries, it will lead people to be very careful when they have to design their distribution network. Because for some products, which are very basic, distribution network is not an issue. But for a lot of producers, like for specialized products like electrical appliances, specialty chemicals, technical products by nature, like specialized vehicles, whatever. In this case, you don't want to have any kind of retailers, because you are going to impose certain standards of training, certain standards of quality for in the act of selling, certain commercial training and all that. And in this case, this can lead that you want to limit the number of wholesalers or retailers that you have. And experience has proven that sometimes some people who are independent purchasers want to become retailers and could make difficulties to you, pretending that you make a refusal of sale. So this kind of situation happens, and now people will need to be more careful in the way they design their purchasing distribution agreements with their distributors. I would have in this case a question more. As a panelist, I'm supposed to have all the answers, but
yes, more or less. I will pick David's brain later on also.
No, but
how he feels about the vertical agreements.
I have read the law carefully, and at primary reading, it looks like now any kind of distribution agreement with distributors and all that would have to be notified to the CCC. Am I correct saying that, or is it just in case of inquiry by CCC that we have to answer to them?
Maybe His Excellency or David can answer that question regarding to distribution agreements.
Clarify the CCC. Ensign, that is your question, right?
Yeah, it's just to know because I mean, so many people design their network of distributors, like, I don't know, car dealers, electrical appliance dealers and all that. And it looks like in Article 12 or 13 on the law, I can't remember by memory, they would need now to, if they consider that they are exempted from any suspicion of anti-competition activities, they would have to get some kind of clearance from the CCC. Does that mean that they have to notify priorly to what they establish, or does that mean it happens only if there is a complaint and CCC is inquiring?
I think based on that article, all the business they wish to merge, they have to notify the.
Merger, I
Sorry?
understand. For mergers, I understand, but for common businesses who are just adding distributors to their lists.
For particular assumption.
Yeah.
I think they also have to request to the CCC as well, you know, to determine whether they're going to grant the exemption for that particular type of the business, like collective assumption and so on and so forth.
So this is a significant change from the past.
Sorry, perhaps I could step in, and I think there's been some confusion here. To grant an actual exemption, clearly you would need that has to go through the regulatory authority. So if you're looking for a formal exemption from the law, yes, of course, that the law clearly sets out that the regulator has, the CCC has to grant that. But that doesn't mean that every distribution agreement needs to go through the CCC. Again, or the CCF, I should say. First of all, you differentiate between vertical agreements in general, which are clearly listed as to what kind of agreements might be problematic, or whether you have a dominant market position, which again, as an ab initio basis, you can take a self-evaluation and see if there might be a problem or not. If you're a very small player in a very large market, the odds of you being dominant are very low. So again, I don't think the idea is to overwhelm the CCF with lots of distribution agreements. It's one, if you consider through your evaluation that there might be a problem, perhaps there's an informal consultation, or if you think there's a serious problem, you might be applying for an exemption. But no, the law is actually fairly clearly worded as to what kinds of agreements are potentially problematic and in what circumstances.
I think that's indeed clear. It's not the idea that you should register or whatever the procedure may be, all your distribution agreements with the CCF. I think that's clear. I just want to park for now maybe that issue of the vertical agreements, because at the end you hinted a bit at the construction sector. And I have a question from the audience before I move to our Matthew. It's a question from Matthew in the audience. It's a bit of a cheeky question, but Matthew asks that bid rigging in the new law is listed only for private contracts. Does it mean that bid rigging is allowed for public contracts, or is there another law we should look at? David, I think that's one for you.
Well, I think the representative of His Excellency could address this as well, but essentially, no, the law is very clear. There is a public procurement law, and that is dealing with bid rigging in public procurement. It's not that it's legal to bid rig in public procurement, it's just not an offense under the competition law, which is focused on private bid tendering only.
Yeah, thanks for clarifying it. Matthew Tippett, do you have something to add to our discussion so far? I mean, you are involved in a lot of association trade bodies, purely based on your own experience on the ground. How common is collusion with competitors in Cambodia? And again, a bit the same question as to Etienne. Is this something that is perceived negatively currently, or how do you see it, especially then referring to the trade associations, which, as David mentioned, can be particularly of interest, I would say, to competition law authorities.
To the question you asked to Etienne, have we witnessed any hardcore cartels in the sectors where I have quite a bit of experience, whether it's financial services, payment, or in the mobile commerce delivery side of things? Not to my knowledge. But when you look at the law and you look at certain services, I think this is where I think the competition law will help certain companies, because in certain sectors, it is evident that very soon, depending on how the definition of dominant market position is characterized, and this is a point that David made, that it has to be dependent as to whether you do have a dominant market position and what is that dominant market position. But the Article 9 clearly states that one of the anti-competitive behaviors, abuses, would be if you start selling services below cost of production. Now, we can look at a lot of financial services or mobile e-commerce delivery companies who are all losing a lot of money, and where these markets have very large players in there, with a lot of smaller players competing against them. And you can imagine that this law will help have a fairer competition across those players, especially when it comes to selling below cost. So I think in the future, this is something to be looked at. I think this is something which will help the industry, especially when it comes to entertaining an ecosystem with multiple players, who some of them are going to be SMEs fighting against very large international companies. And that I think is good for Cambodia.
Right. Thanks, Matthew. We'll talk later also a bit about the specific issue which you raised here about dominance. And I see that before His Excellency wanted to add something. But before I give the floor back to His Excellency, maybe I will immediately add a question also to Excellency Van Un. I think we are all in agreement today that competition law, and not only the Cambodian one, but in general, it's a fairly complex area of the law. And it's also subject to, I would say, ever-evolving economic and legal insights. Do you feel, Your Excellency, that the Cambodian business environment is actually ready for this law? I have a European background, and we have competition law has evolved over the last 50, 60 years there, and still we are training companies on what you can and what you cannot do under competition law. And it's an area which is heavily dominated also, especially the vertical side by lawyers, because it's particularly technical. So my question really is, how can we address this, I would say, information gap, or how we can reach this behavioral landslide towards legal compliance with this new competition law?
I think as all the speakers have mentioned, that the competition is economic law, which is need the economic analysis is very, very difficult, especially calculation the market dominant, market powers. As I had attending the training with David a couple of times, and still have some doubts on the particular of how we're going to use the tools to calculate the market dominance. So what we can say, which is the advocacy program, which is very important parts that we engage with the industry, sharing what we know, and then industry share with us what they know, and then we can have proper tools, So it's going to take time, as you mentioned, like EU, they have this law like 50 years, 60 years, US maybe they have more than 100 years. Some other ASEAN countries, they have like 20 years time, but they still facing with a difficulty, So the competition law is complicated. It requires, I think, some training on the calculation of sophisticated tool. We need to have the guidance, like David had mentioned, that we need to have the guidance that need to be written as well. And with the industry, we also have to have the profession, some material for the publication, so that we can engage the industry to be aware that the laws are in place. Like you mentioned before, that if the industry have a reluctant, and maybe they consider that they might violate the law, then they can apply for CCC to seek for the assumption, which is stated in the Article 12, especially in particular for the market dominant position, which is very difficult. So they can apply if they trust that they are not violating the law, then they can just have a particular agreement on the vertical side. But if they are not sure with that, then they can just come to apply for that assumption with the CCC. So there's a lot of, let's say, a lot of material that we need to build on, and also there's a lot of capacity buildings on all of this issue. So I believe that we can just run, and we can just continue to work how difficult it is. CCF will try to learn from other best practices and also from other countries as well.
Thank you, Excellency, and I fully agree with you, of course, that this will be a process. But a question for David. And I see a lot of questions also in the Q&A relating to vertical agreements, distribution agreements. What is a bit your assessment of the impact of this new law on the existing distribution agreements? Some people are panicking. For example, if I currently have an RPM clause in my distribution agreement, what should I do? Am I immediately now in defiance of the law? Should I renegotiate my distribution agreements right away? And what is your advice as a lawyer? Because oftentimes, of course, the contractual balance will suddenly change. How can businesses go about this? I would say sudden change in their distribution relationships.
Well, first of all, it's important to recall I'm not a Cambodian lawyer. This is more from a general perspective than a Cambodian specific perspective. But again, I think the law is fairly clear in sort of alerts you have to go through. The first, again, if you start with the per se versus rule of reason dichotomy, the only vertical agreement, in other words, the only agreement that may apply between a company and its distributors that is per se prohibited is a minimum resale price maintenance. So that's an easy question for businesses to look at. Is there minimum resale price maintenance or similar direct or indirect or similar conditions related to that involved in this distribution agreement? If yes, that is problematic. And again, that's a plain and ordinary reading of the law. And again, because there are no what we would call basket clauses, in other words, the law clearly enumerates the types of agreements that are potentially problematic, either as a vertical agreement generally or as an abusive dominant market position. So in a lot of other jurisdictions, there are what we would call basket clauses that talk about other agreements that may have this effect or object. Because that's not in Cambodia, it actually is much easier for businesses to interpret and look at their agreements and basically have a checklist of, does my agreement cover this provision? If it doesn't cover this provision, it's not within the scope of the current version of the vertical anti-competitive agreements or abusive dominant market position. That may change as the law evolves. It is very common and you see this with our ASEAN neighbors, to amend and replace competition laws as things develop. But at an early stage where there isn't an underlying basis of competition knowledge and expertise, this is a very clear and straightforward way for both enforcers, third-party experts, whether they be lawyers or economists, and businesses to clearly identify potentially problematic conduct. Is it within the law? If it's not exactly within the law, it's probably okay. Then the test for between vertical and dominant and abusive dominance is not clearly set out yet. We don't know what's going to be. I know in some jurisdictions they went to market share only, but I think I've explained why I think that hopefully we won't go there. But market share is definitely a part of the analysis. And so if you can look around as a business and see what is your relative what do you think your relative market position is? And that tells you sort of, is this a red alert problem? Is it an amber alert? You have to be cautious. So I think businesses, while they should be concerned, it's not a crisis. This is normal business practices in many regimes, and the Cambodian law, I think, is clearly set out to avoid the.
I think we lost David. That may be his power issue coming up now. Let me just quickly address an issue which I see here in the Q&A. It's a question from Sophia.
Hello? Hi, as I was afraid my power went out, so I apologize if anything was cut off, but basically my point is that I think the law clearly enumerates the relevant provisions, and this is a clear guidance for businesses to review their distribution agreements on an ex-ante basis without the need for going to the CCC or CCF at all times for exemptions. They can first determine whether there might be a problem. And then, as I said, it's very common, especially in developing regimes like our ASEAN neighbors, for considerable amounts of informal consultations where there is potentially a problem. And I think that will become common here as well.
I would like to very quickly pick up a question from the audience, because it's a bit of a question which is important for the basic understanding. So the question is, does resale price maintenance to the distributor violate this new law, or can we recommend the customer for the resale price to other consumers? Just to confirm, David, that the RPM would only be illegal if there is a minimum price, and that indeed you can recommend prices to your distributors.
Sorry, so again, the law, it does not prohibit resale price maintenance, either on a per se or rule of reason basis. Only minimum resale price maintenance is covered. There are lots of, and again, while it is a broad interpretation because it includes direct or indirect, I think businesses can clearly identify if potentially they have minimum resale price maintenance. Now, when you're looking at things like suggested retail prices, that can be a form of indirect RPM. For instance, what happens if you don't follow the recommendations? Are you punished in some ways? If yes, that seems to fall under the definition in the law that is per se prohibited. But again, I think the law is, we don't understand exactly how broad it will be or what indirectly will be precisely determined at, but it's written in a way that businesses can have a first glance look and see if there's a potential problem.
We only have a few minutes left, so I would still like to address one or two other topics just very briefly. And maybe a question to His Excellency, if you could elaborate a bit what you think will be right now the priorities for investigation and prosecution. And allow me to touch upon a bit my second point also, because we have Matthew Tippett here, so I would like to address the digital sphere also a bit. In Europe, this is really currently a big item, and the interest of the Commission in particular in the big tech sector, companies like Google, Amazon. And oftentimes I would say the investigation or the prosecution priorities, they also are a bit politically sensitive, in the sense that it's sometimes perceived that the European Commission is going after those typical big US companies, those Silicon Valley companies. Do you think, Your Excellency, what are your views a bit on how we can reunite competition enforcement with still being an attractive investment destination?
Just allow me to just give you a very brief answer to this question. I think with respect to the enforcement, it is very common in ASEAN for competition regime to just structure the enforcement, beginning with the anti-competitive horizontal agreement, as these cases are typically less difficult in terms of analysis and more focused on investigating techniques. For the example, Malaysia and Singapore, they start the implementation enforcement with low-hanging fruits, with small local cases where less sophisticated and complex. This is from my the strategy that CCF will do it, and then also recommend the CCC to start with the small case and then keep learning the big cases, like you mentioned, in terms of Google and and other giants or other big corporations.
Thank you, Excellency. And Matthew, what is a bit your view on the relationship between, I would say, the new competition law and especially the online marketplaces, which are ever growing? Do you think that the competition law may pose or may risk restricting Cambodia's digital development? It's also, I think, but that's maybe an area David can further address, relating to the price differentiation, for example, between brick and mortar shops and online shops. But just in general, Matthew, what is a bit your take on competition law versus digital development?
I'll go back to one of the points of His Excellency and Mr. Meng, that the competition law is one thing, but it overlaps with other law frameworks which are very important, like consumer protection and data protection. And in the case of your question relative to online marketplaces, critical for these marketplaces and for developing these businesses is, the monetization of data, right? And that in itself is not a bad thing, but what is bad is when it's done in a way which infringes on the data privacy and impacts the competitivity of a company on that marketplace. Hence, if it's done properly, it should not hinder marketplaces. But if there are going to be breaches used to develop these marketplaces, then they are going to be hindered, and it's perhaps better that they are in any case, because you want a level playing field. You want a playing field where everybody can compete. And for marketplaces, marketplaces are, I wouldn't call it the epitome of an ecosystem, but it is an ecosystem. It's a marketplace. You want many people to be on that place and to be able to compete on a level playing field. Hence, it's very important that they do respect these laws, whether it's competition, but I think it's also a lot about data privacy, I think. So if everybody's looking to do business on a level playing field and leveraging that technology for that, I think there won't be any problem. And Cambodia has mass growth potential relative to that, mainly because it is the most fastest growing industry when it comes to retail, and it does bring a lot of efficiencies, as we've seen with the COVID crisis, when it comes to getting to do a face-to-face transaction. So I think this is for the better.
Good, very good to hear, reassuring also. We're going slightly over time, but I will allow myself just 4 or 5 more minutes for one technical question and one more policy-related question. And the first one is a question from the audience, and it relates to the enforcement or the sanctioning part. Is that penalties, they are based on the turnover generated by a person, but how is that turnover exactly calculated? Is that in relation to Cambodian market?
And I think for the calculation of the turnover, again, the penalty, we're gonna drafting on the how to calculate the turnover of the industry. When we have the penalty from 3 to 10%, then it coming next for that. We have to the study on how to calculate the turnover of businesses.
Okay, we close our panel discussion with a more policy-oriented question to Etienne and maybe also Matthew. Regime about the current M&A market in Cambodia. Do you feel that a lot of the M&A market is really being occupied by those large players? Is there currently a lot of M&A activity going on? Do you feel that as an entrepreneur yourself, you have difficulty of doing a takeover, for example, what we see emerging in Cambodia? Etienne?
Well, M&A is when you want to differentiate between the large one and the small one is because of sectors. For example, if you go to the distribution sector for supermarkets and all the rest, it has to be large transaction because you already have large players all around. But there are a lot of medium size and dynamic sector for M&A for SMEs and tech companies. For this, there is no particular issue of anti-competition. You have to understand that it's important for the people who are listening to us. The landscape for anti-competition is fundamentally different whether you are a dominant player or whether you are a small or challenger position. If you are a challenger in the market, you have to grow, you are a new startup or whatever, you can use right of first refusal in your contracts for further supplies. You can use kind of control of pricing with the distributors that you are going to choose and that, as long as you can demonstrate that it has no detrimental impact for the consumer. So a small player has more agility and more creativity for his contracts than a big one. So this kind of law is mainly oriented for big players who come to a relatively small country like Cambodia and try to play games. So for entrepreneurs or SMEs, they don't have to be afraid of this new law, I think.
Thank you, Etienne. Matthew, you want to add something?
I've been in Cambodia for 10 years and I was a tech banker before. I would say that as Etienne put it, you know, it depends on the sector. If you're looking at distribution, you're talking about very large companies. But if you look at financial services, I mean, we have over 50 banks for 16 million people, 17 million people. If you look at, you know, online marketplaces for delivery, I mean, you've got perhaps a dozen players. We're at the beginning of the industry. I don't think as of today, the competition law is going to create immediate problems, but I think it comes to also when you've got in certain sectors, such as, for example, marketplaces and delivery, last mile delivery businesses, these are by definition scale businesses, right? Where you will derive a competitive advantage by scale. And that's what you end up with, a winner takes all market in other countries. Cambodia will follow the same development. So yes, the market will hold multiple players, but you will find that some of the leading players will have a very large market share. And this is where things get difficult, as I pointed out before, in terms of, you know, how do you calculate that somebody has a dominant market position or not? It's very difficult because the market is growing fast. You've got massive disparities of resources between these different companies. So it's going to be very interesting to see. But as Etienne put it, I don't think as of today, the competition law poses any problem, but I think for certain players, but I think it does help in the medium term create a more level playing field in at least on the tech side, a very dynamic market. Now, just to finish on that point, as much as people have been predicting a lot of M&A among banks, which never materialize, and you just get more and more banks, if you look on the tech side of things, in general, with SMEs, it's very rare, at least when you look at other markets, to see a lot of M&A among smaller companies. You could see larger companies looking at smaller companies which have very strong niches. And I think if we saw that, that would really show that there is a healthy market. And I hope it goes down that way. But it's difficult. In general, M&A for tech companies which are very small. So I wouldn't expect too much, but if there is, and I'm proven wrong, I think that shows that we've got a strong, healthy ecosystem.
Great. Thank you both for your answers. Still enough food for thought. Chris, do you allow me for one more technical question to David, just for 1 minute?
Yes, please.
Okay, because I just want to end on a positive note and to clear out any final thoughts. But a technical question to David, and I know you addressed it before, but I think there's still some confusion among the participants. So relating to dominance in the market, can you re-explain how much percentage of a market share is needed before you are considered dominant?
First of all, the answer is there is no market share in general economic principles that leads to dominance. I think you will have trouble finding an economist anywhere who would argue even 100% market share is necessarily dominant. Many countries put in market shares as guidelines or to create safe harbors because it's a necessary but not determinative factor in determining dominance. In other words, very small market shares are highly unlikely to ever create dominance, almost impossible. But large market shares are not necessarily dominant. And it depends on the market structure and a number of other issues. And again, what was market share. And I just want to make really short note. I think there were some comments made about the problematic effect of the competition law in various sectors. I want to differentiate again between horizontal per se issues and rule of reason issues. Regardless of your sector, regardless of whether you're a big or small business, businesses need to pay attention to the per se prohibitions. They're not about market effect or object or anything like that. Many small entities, the local delivery guys, could have a pricing cartel. Secondly, with respect to acquisitions, a lot of the controversy right now among tech companies is in fact about large companies acquiring small ones. And that does show a dynamic market, but it also creates problems. And you can see that everything from Facebook acquiring WhatsApp, which was not notifiable, in ASEAN, Uber and Grab. So again, size is not necessarily determinative. And there are different words for this, zombie acquisitions, et cetera, but there is a large history of pharmaceutical companies, tech companies, and other industries of acquiring smaller competitors in a fashion that has been determined to be anti-competitive. So I don't think the law is problematic, but I would not say that any industry or sector is safe at this point. It depends on what provisions you're really focusing on.
All right, thank you. I think that's all we can do for today in our introductory session. Thank you very much, Excellency Van Oon, for your insightful remarks. Thank you, Matthew. Thank you, Etienne. Thank you, David, also. So I'll end the panel discussion here. I know there are still some technical questions which we weren't able to address, but definitely I think it's worthwhile that we have another session soon to address these as well. So with this, I'll hand over the meeting to Chris. Thank you very much, everyone.
Thanks, Noé. Just to echo, given we're over time, just to echo your sentiments there, Noé, I'd like to thank all the participants today. Firstly, representatives from the Ministry of Commerce and CCF, represented by His Excellency Van On, for his opening remarks and providing a very clear overview of the regulatory framework and also the key tenets of the competition principles and particularly the goal of trying to create a level playing field. And complemented by Mr. Pen Viriakodom with his very comprehensive overview of the law, particularly the very clear explanations of unlawful activities, as well as the accompanying sanctions and penalties and process for exemptions, as well as the enforcement plan, which is obviously relevant to us all. I'd also like to thank David. He's, as you would have sensed from his answers in the panel, he's got a very comprehensive experience in competition law over 20 years, and was very interesting to hear his thoughts and practical recommendations for business to reflect on the informal discussions you have, participations or interactions with other competitors to ensure that you don't commit any per se offence. And to the panel, particularly Etienne and Matthew, given your extensive experience in industry and participation in businesses throughout the region, thank you for sharing your insights on the relevance of of various issues to the Cambodian business community. Finally, or secondly, I'd like to thank the participants. There's a lot of people attended today, close to 150, and there were a multitude of questions, all ably handled by Noé. So thank you for those insightful questions. As mentioned on a number of occasions, there will be further updates in terms of the regulatory framework. So DFDL will be providing updates in due course. And finally, a big thank you to EuroCham, another expertly managed event. As mentioned earlier, compiled a fantastic panel, which addressed obviously some very interesting questions. So I'll hand back to the MC just to address a few housekeeping matters to close. Thank you.
Thank you, Chris. Thank you, Noe, and the entire panelists indeed. So I think it's all come to an end to this webinar session. I just want to mention that the recording version of this webinar will be available in the coming days on EuroCham's social medias and across our YouTube channels as well. Feel free to go there and rewatch it again. And thank you to Excellency Panon and the entire CCF team for the collaboration. Thank you, DFDL, for the collaboration also. And EuroCham will be looking forward to further updates on this law, and we look forward to another great events in the coming futures. Thank you all, and have a nice evening.
Thank you.
Thanks. Thanks.
Thank you.
Thank you.
Thank you.